Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. I have heard from some of you who are distressed because Social Security denied your application for Social Security benefits. Hey, I get it. You rely on Social Security to survive. So, what I decided to do was produce a video on this very subject. I want to give you step by step how to appeal to Social Security to approve your application and what you can do in the event Social Security does not approve the application. And even though it's a step by step video, you will still need to engage to become familiarized with the processes that I'm going to introduce. Okay? So let's get started. Under Sections 205G and 1631C3 of the Social Security Act, a claimant or other party to a hearing has the right to file a civil action requesting judicial review after any final decision of the Commissioner of Social Security made after a hearing. And the manual we're going to be referring to is the Hearings, Appeals, and Litigation Law Manual. The acronym for that is Hallex. And we'll be looking at Section I-412. And I will leave you a link where you can download this manual. But let's first look at some things you can do before you file a civil action against the Social Security Administration. Ask the Social Security Administration to reconsider its decision. Now, typically, this would involve someone different than who presided over the matter previously. Two, request a hearing with an administrative law judge if you don't agree with the Social Security Administration's response to your request for reconsideration. Request a review with the Appeals Council if you don't agree with the decision made by the judge in your hearing. Then, if all fails, file a lawsuit with the United States District Court if you don't agree with the response from the Appeals Council. You would file a complaint against the commissioner in a federal district court. Now, of course, the complainant could sue on his or her behalf. The complainant is no longer required to serve a summons and complaint on the commissioner. The Federal Rules of Civil Procedures now requires the court to notify the commissioner of the civil action. The complainant files a civil action in the federal district court in the judicial district where they reside or have a principal place of business, or in the federal district court for the District of Columbia. For example, if they reside in a foreign country. Let's look at when the lawsuit is due for filing. A claimant generally has 60 days following receipt of an appeals council decision, denial, or dismissal of a request for review to file a civil action. The AC presumes that the claimant received the AC notice within 5 days after the date of the notice, unless there is a reasonable showing to the contrary. And what this means, the complainant would have 65 days. Let's assume that the complainant has filed the civil action. Let's look at the Social Security Administration's response. Now, the commissioner may answer, and for its answer, it usually uses the certified administrative record on which it based the final decision. The court may dismiss the case, or it may affirm, modify, reverse, or remand the commissioner's decision for further proceedings. For example, the court may send the case back to the Social Security Administration and require that the administrative law judge, for example, reconsider his findings and why he or she made such findings. And one important issue that comes up quite a bit when the administrative law judge is adjudicating the matter is how he or she weighs the evidence. And that's something that I expect to do in a future video, is talk about the administrative law judge and how he or she weighs the evidence, because that is critical. And claimants need to understand that process and what to look for when determining whether to proceed further, such as appeal the case. And under Section 205G of the Act, the court reviews the commissioner's final decision using a substantial evidence standard. For example, the court reviews whether the decision is supported by substantial evidence. And that is critical, because this too takes on the conversation of whether the administrative law judge weighed the evidence. And of course, assuming that the complainant wishes to move further, he or she may file an appeal pursuant to Federal Rules of Appellate Procedure 4. Hey guys, be proactive, be empowered. Take care.